In this video, I want to quickly go through a brief overview of what we've spoken about over the last 13 weeks and talk briefly at the end about what you can expect from the final exam. So we're here at the end. We've done a fairly quick survey of the different forms of intellectual property. So we started with copyright, we moved on to trademarks, we briefly covered registered designs, passing off and breach of confidence, and then we spent a bit more time in detail on patent law. So the amount of time that we spent on each one of those topics really gives you a sense or an indication of how deeply you'll be expected to know those topics. So you'll need to know copyright law in much more detail than, say, breach of confidence. What we're going to be doing in the exam is really assessing your ability to answer a practical and complex fact scenario. What we're looking for is really a good ability to answer a practical question. We're not trying to trip you up with this exam and get you to discuss really tricky, cutting-edge, current issues of uncertainty in the law. We're not looking for you to have an encyclopedic knowledge of all the intricacies of intellectual property law. Intellectual property law is a notoriously arcane and complex area of law. It used to be really quite unpopular and something that's only the most specialist of lawyers would spend much time on. It's now much more general in its applicability. There are lots and lots of IP issues in many different types of commercial and even non-commercial problems that arise just out of the normal transactions of everyday society. So along those lines, what we're trying to do in this subject is not to make you an IP specialist. We want you to be a generalist who knows the IP issues, who can identify the issues that might come up in normal practice, who can apply the law to the basics, the most general or the most common types of legal issues that might come up involving IP disputes or IP issues, and who knows enough to not get in trouble in IP. So you need to be able to apply the law, and we're assessing your ability to apply the law to a general fact scenario that is going to be a complex fact scenario. So you'll have to read it carefully and work hard to understand it. But it's not going to be a tricky, out of the ordinary thing. You're going to have to just really clearly demonstrate your ability to apply the law to a practical scenario. Now, we'll write this in a way that will likely involve a number of different areas of IP, and everything we've studied so far will be examinable. But as I said, the depth to which you'll be expected to know each of those areas will change. So you'll need to know copyright, trademark, and patent in some depth. And then for the other areas that we've covered, you really just need to know the basics of how they apply and when they apply particularly. Your hardest task, I think, in this assignment is going to be identifying the issues. So one of the challenges I think that you will face is knowing the law well enough to understand when something is likely to come up. So we'll give you a fact scenario that can be quite complex, and we'll expect you to spot when the different parts of IP law are going to be relevant. And this is the most important thing that you can do in this for this exam, which is work out when different interests are protectable by different forms of IP. And unfortunately, that sort of thing only comes with familiarity. So you're going to have to practice, and I suggest doing the past exam questions to practice your ability to spot the issues and apply them. Because once you apply them, I hope that it's relatively straightforward. As I said, we're not going in for loads and loads of detail and really complex and arcane points of law to try to trip you up. We once you identify the area of law that applies and the types of issues that might arise, then it should be as simple as developing a structure and following that structure through to make sure you tick off all of the boxes that you need to in a checklist in application of particular, whether it's copyright or trademark or patent or whatever it is. But identifying the issues is going to be difficult. And you'll need to have enough practice behind you in order to be able to reliably pick up the different areas of law. And that can be quite complex. So what I suggest you do is have a go at the past exam question. Okay, onto the areas of law. What I want to do in this brief video is just quickly recap the things that we've talked about over the last 13 weeks. So the first was copyright. And you remember, copyright is the body of law that protects expression of ideas. It doesn't protect the ideas, it protects the way that they're expressed. There are two categories of copyright protection: original works, which are literary, artistic, dramatic, and musical works. And there are the Part 4 productions, subject matter other than works, which includes sound recordings, films, and published editions and broadcasts. Okay, so copyright, you've got an easy 5-part structure. First, subsistence. What are all the works and other subject matter in which copyright could subsist? And you have to go through and make sure you identify every particular work or other production in which copyright might subsist. And this is important because they might be owned by different people. So you need to work out exactly what types of works there are. You also need to work out whether they're Part 3 or Part 4, because that changes the infringement equation. Remember that Part 3 works can be infringed by non-literal reproduction, whereas Part 4 works are only infringed where a direct copy is made of the subject matter. So 1, subsistence. Identify every work. Identify every original, literary, artistic, dramatic, or musical work, and then identify every Part 4 subject matter: broadcast, film, sound recording, published editions. Then, for each one of those, identify who the owner is. General rule: the author of a Part 3 work is the first owner, and the producer of a Part 4 subject matter is the first owner, always modifiable by contract and certain default provisions in the Act. Then, step 3, infringement. Identify for each one of those works, identify which right might have been infringed, and be specific here. So you say the Part 3 artistic work might have been infringed by a reproduction in these circumstances, and you explain what reproduction means. Reproduction has 2 elements: causal connection, access to the work, and objective similarity, taking them side by side and looking at them. Otherwise, you're looking at the basic rights, the right to copy when a direct copy is made. The other one that often comes up is the right of communication. This one will come up in relation to internet distribution or other electronic distribution. That one comes up a lot. And the third or fourth common one is indirect infringement by, for example, importing goods for the purposes of selling or renting or so on. So when you've got physical goods, you might have indirect infringement. When you've got digital goods, you're looking at communications. Otherwise, you're looking at copies and reproductions. The other thing you need to do in the infringement stage is work out whether a substantial part has been taken. And remember that this is a qualitative, primarily, rather than a quantitative test. Then we turn to defences. And under Australian law, we've got the fair dealing defences. You need to know basically what they are: criticism and review, parody and satire, news reporting, research and study are the main ones. So you need to check, is the dealing for those purposes? And then second, is it fair? Has more been taken than is necessary in each one of those cases for each one of the works? Okay, so it can get quite complex when you're dealing with multiple works and multiple potential infringements. Then remedies, standard remedies that are almost the same in every one of these: damages, where there's harm, or an account of profits, where there's benefit, and an injunction almost always. Sometimes there are criminal remedies if it's been done on a commercial scale. So that's copyright. Pretty basic. It's very complex in its detail, but the overall structure is basic. 5 steps that you go through in every copyright question. Then we get to moral rights, and there are 3 main moral rights in Australia. Attribution and right against false attribution, pretty straightforward. The tricky one is integrity. Remember that integrity is a right to object to anything that results in a material distortion or mutilation of an author's work. Only natural people get moral rights. Corporations do not get moral rights. The distortion has to be a treatment of the work that is prejudicial to the author's honor or reputation. So in answering a moral right of integrity question, you need to be absolutely clear in pointing out how this treatment is likely to harm the author's honor or reputation. And it can't just be to say that the author doesn't like it. You have to show that it's likely to diminish respect for the author or something else that is likely to harm them personally in a way that we recognize. Then we move away from copyright to trademarks. We spent a few weeks on trademarks. Most trademarks are a little bit, it can be a little bit confusing because we have to apply the tests both at the registration stage and then again at the infringement stage. And all of those tests are used at both stages. So registration first. A trademark is a sign, and that's pretty broadly defined, as we saw. It can be normal signs, images, and text, or it can also be non-traditional signs like sounds and colors and smells. It's a sign that's used to distinguish goods or services. So you need to be able to explain whether that sign has been used in a way that is that is designed to distinguish a trader's goods from another trader's goods or services. And registrability requires you to show either that the sign is inherently distinctive, that's a unique sign that is capable, as a matter of course, of distinguishing goods or services, or that it's partially distinctive but not quite enough, but is likely to become distinctive in the future, or alternatively that it's not distinctive at all, but it's been used to such an extent in the past that it does in fact distinguish in the market. That's called acquired distinctiveness. And then you just have to go through the Trademark Act and remove or check that the trademark doesn't breach any of the conditions of registrability in the Trademark Act. So it's relatively easy to work through those registration requirements as long as you're methodical about it. Then infringement. And you remember that there are 3 different types of infringement in the Trademark Act. So first requirement always is that the defendant is using the sign as a trademark. That is to say, not all uses of trademarks will trigger potential infringement. Only uses of trademarks that are used to distinguish the defendant's goods or services in the course of trade will count as a use of a trademark. The defendant needs to be using the mark or a sign that is substantially identical or deceptively similar to the mark, and those tests are the same as under registration. And they have to use it in particular categories. So if they're using it in relation to the same goods or services, that's the end of the analysis. The trademark that's almost always an infringement. If they're using it in relation to closely related or similar goods or services, then there's an extra requirement that there has to be a likelihood of confusion. So if the defendant can show that there's no likelihood of confusion in relation to similar goods or services, then there will be no infringement. That's 120 sub 2. And finally, in 120 sub 3, the protection for well-known marks. Kind of like a passing off action, but statutory and a little bit easier to prove. Still not that easy to prove. But where a defendant is using a sign or a similar sign in relation to unrelated goods and services, and the mark is well known, and the defendant's use indicates a connection with the well-known mark, and as a result of that connection, the plaintiff is likely to suffer harm. Then 120 sub 3 might allow someone to prevent a use of a mark in relation to unrelated goods or services. But remember that the general rule is that trademark law is about consumer confusion as to the origin of goods or services. And if there's no consumer confusion, there's usually no action for infringement. That leads in quite easily to passing off. Now, passing off we did very quickly. So you need to know 3 things and the case law that supports it, but you don't need to know it in much more detail than that. So passing off, the 3 tests, the classic trinity. 1, reputation. The plaintiff has some sort of reputation in the market. 2, there has been a misrepresentation. And this one you need to show. You need to show on the facts that the defendant has misrepresented the origin or some sort of connection to the goods. In all of these questions in the exam, what I'm going to be looking for is your ability to apply the law. So I don't need you just to state what the test is and to come to some sort of conclusion about whether the person is liable or not. What I need you to do specifically, and the one thing that people really usually forget to do that is absolutely crucial, is that one bit of application that says, for example, in passing off, the misrepresentation on these facts is X. And you explain what exactly the defendant has done or has not done that gives rise to the potential action. Now, this is really, really critical. In all of these different areas of law, the one thing that law students tend to mess up is not to give me that crucial sentence of application. You must say, on these facts, because of this set of facts over here, we can draw the inference that the defendant has done something. Whether that is communicated the work to the public, or whether it's misrepresented a connection with the plaintiff. You need to explain how we get to that point on our facts. You need to show your working. Right. Back to passing off. The third element, harm, fairly easy to show. Interference with the market, blah, blah, blah. Loss of ability to distinguish, etc. Okay. Passing off. Registered designs, breach of confidence, you only really need to know in outline how the tests apply and what sort of facts in what sort of circumstances they're likely to apply. So registered designs, you need to know that a registered design protects the visual features of products that are new and distinctive compared to the prior art base. Okay, so you need to know basically what sort of things can be registered as designs and when they're not likely to be able to be registered. You also need to know when copyright is likely to be extinguished, but I don't expect you to launch into a huge amount of discussion about whether something is a work of artistic craftsmanship or not, and know all of the fine detail of that fairly complex body of case law. You need to know the test for infringement, which is to make or use a design, etc., in a way that embodies the registered design. And that's about it. Next, moving on to breach of confidence. Again, 3 things you need to know, fairly simple. 1, the information has a quality of confidence. The information is confidential. 2, the tricky one, that the information has been transmitted or divulged in circumstances giving rise to an obligation of confidence. So I suggest that you work back through those lectures and work out what sort of circumstances give rise to an obligation of confidence. Now, normally the obvious ones are where there's a contractual obligation, non-disclosure agreements, where there is a expectation because of the relationship between the parties that the information will not be disclosed. Then we get to the ones that are a bit trickier, where people surreptitiously collect information or where people stumble across information that on its face is probably confidential. And they're the basic outlines of the circumstances, and you need, and really in order of most strong to least strong. And then third, fairly easy, threatened or actual disclosure. And that leaves us with patent. So patent, you need to know the tests for registration. You need to know, and Ben's got a nice diagram here, you need to be able to work through the materials. An invention is a patentable invention if it is a manner of manufacture within the meaning of the statute of monopolies, and we spent a lot of time discussing what exactly that means. When compared with the prior art base, which is the existing field of knowledge relevantly defined, at the priority date, again, relatively defined, you have to go through and make sure, identify what the priority date for a particular application is. Then the patent or the invention is registrable if it is novel compared to that priority art base and involves an inventive step for a standard patent or an innovative step for an innovation patent. The patent must be useful, and there is a prohibition on secret use and other things that prevent or will ruin a patent's eligibility for registration. Just work through all of those in a fairly logical manner and you'll be okay. So the biggest tip I can give you for the exam is, well, two big tips. One, get some practice in, please. I am a little bit concerned that people haven't necessarily been staying up to date with the materials in this subject, and I worry that if you haven't had the opportunity to do that, if you hadn't had the opportunity to work through the workshop questions every week and to try applying the law and getting feedback on the law, I worry that you're not going to be able to do. So the biggest tip I can give you, make sure you answer the question. I know it sounds obvious, but as I said earlier, the key mistake that people often make is not to show the point of application. So people will often give a statement of law and a conclusion, but they'll miss the middle step of applying the law to the facts. And that's what gets you marks. Anyone can state the law, copy out from the textbook. I don't want to see that necessarily. What I want to see is why on our facts you come to the conclusion that you have. And that's what I'm going to be assessing you on. In order to do that well, you need to be clear about what areas of law apply, what areas of IP apply in different scenarios. So as I said at the start, the hardest thing you're going to find in this subject, in this exam, is to be able to identify which of the various doctrines of IP are likely to apply in relation to the specific facts in which you're given. So you need to be able to easily identify from a fact scenario what sorts of IP protection are likely to be relevant. One mistake that people make a lot is to spend heaps of time on an area of IP that just isn't practically applicable to the fact scenario. So people might spend heaps of time talking about breach of confidence when there's clearly no confidential information, or talk about trademarks where there's no registered marks, or designs where there's no registered designs. There's no point going through all of that material if it's not applicable on the facts. There's no point going through patent law on something that is not an invention or where there's no registered patent rights. Particularly with the registered rights, you know immediately whether or not something has been registered. That'll be given in the facts. So if there's no registered patent, there's no use talking about potential patent infringement. You know that immediately. But you need to be able to pick this up